Here is important information from the Health Law Firm.
The term fair hearing is used by hospitals and other healthcare organizations to refer to their internal medical staff peer review hearings on adverse action being recommended against a physician. By federal law and often state law, there must be certain due process rights given to the physician to make the hearings fair, hence the term fair hearing. Sometimes such hearings are held pursuant to the medical staff bylaws to determine if a physician should be granted clinical privileges in certain areas of medical practice. However, if the physician already has clinical privileges, then the fair hearing is used to decide whether the physician's privileges should be limited in some way or taken away completely, for example, because of their lack of competence. The health law firm's president and managing partner, George Indest, says the peer review fair hearing process is different at every hospital and healthcare entity. Therefore, you must obtain the medical staff bylaws and the policies and procedures that apply in order to determine the physician's exact rights and what procedures will be followed. Subjects of a fair hearing must understand that the hospital's personnel and attorneys will provide all of the support for the medical staff and the fair hearing committee. The hospital and medical staff will have access to expert witnesses to testify against you at the hearing, including unlimited access to hospital employees and documents to use against you. The hospital's budget to use in making a case against you will be virtually unlimited. Therefore, you must obtain experienced legal representation as soon as you learn that you are being investigated or that such proceedings may be initiated against you. It is up to you to pay for your defense, including hiring expert witnesses to review records and testify at the hearing. This is probably the largest expense involved in such proceedings. The peer review fair hearing process can be overwhelming. Do not wait and see what happens. Do not take advice on this from your medical staff peers. It will not just go away by itself. You must be represented by an experienced, knowledgeable healthcare attorney during the investigation and hearing process. An experienced healthcare attorney may be able to develop creative solutions that might avoid a fair hearing. Such options may include agreements to not admit patients, undergo external skill and competency evaluations, attend classes such as anger management, boundaries, medical training, continuing medical education, undergo monitoring of a certain number of cases going forward, participate in focused professional review, take a leave of absence, or other measures not considered to be adverse action. If you are the subject of a peer review investigation or hearing, immediately consult with experienced, knowledgeable healthcare counsel to represent you. The attorneys of the health law firm have experience in hospital peer review matters, medical staff bylaws issues, and in representing physicians at fair hearing across the United States and in military services. The health law firm and its attorneys will be there to advise you and guide you through your dealings with fair hearings. Call the health law firm today or visit healthlawfirm.com for more information.
For more information, visit thehealthlawfirm.com.